Kerajaan memutuskan untuk melaksanakan Perintah Kawalan Pergerakan mulai 18 Mac 2020 iaitu lusa hingga 31 Mac 2020 di seluruh negara.
Freedom of movement is an important fundamental liberty recognized in the Article 13 of United Declaration of Human Rights. This liberty is common and yet closely related to our daily lives. As in Malaysia, our government had highly committed to provide its citizens this ultimate freedom of movement as declared in the Article 9 of Malaysian Federal Constitution. As an example, interstate travel is not forbidden by the state. However, the state can actually restrict your freedom of movement. So, in this video, we are aimed to discover the relationship between current law to the freedom of movement, as well as this law affects the other fundamental liberty that is stated in Federal Constitution.
In Malaysia, the article in the Federal Constitution that governs the freedom of movement is under Article 9, Clause 2, which has listed out clearly that, subject to Clause 3 or to any law relating to the security of the Federation or any part thereof, public order, public health, the punishment of offenders, every citizen has the right to move freely throughout the Federation and to reside in any part thereof. To interpret it simply, this means that unless there are any other laws relating to national security, public order, public health, and the punishment of offenders, which restrict the public from exercising this right, every citizen can move freely and choose to live wherever they wish within the Federation. So this right is actually subject to the interest of the public. To further elaborate, one of the current cases we can look at is Asa Singh and Menteri Besar Johor, 1969. This is a relatively old case, but the precedent still applies. In this case, the applicant was arrested and detained by the order of the Menteri Besar of Johor under the statute Restricted Residence Enactment, which from now on I will call as the enactment. In this enactment, the Menteri Besar of Johor had powers devolved to him by the Ministry of Interior and Justice. The applicant filed his claims on the ground that the enactment did not have any provisions that could amount to his arrest and detainment, to present him before a magistrate's court, to review and to set a limitation on the period of detention. The applicant argued that the provisions of the enactment were not compatible with the Federal Constitution, therefore the enactment should be void. However, the court held that the enactment was constitutional. This case deals with several articles in the Federal Constitution, but today we will only be focusing on the parts related to Article 9, which is the article that governs the freedom of movement. The court held that the arrest and detainment of persons concerned were in line with one of the exceptions posed to the freedom of movement in Article 9, Clause 2, because it is related to national security and punishment of offenders. According to the dictum of Judge Raja Azlam Shah, the rights protected in Article 9, Clause 2 are not absolute rights. They may be subordinated to larger social interests. Each of these rights is liable to be curtailed by laws made to be or to be made by Parliament, subject to Clause 2 read with Clause 3. Judge Raja Azlam Shah also opined that in Article 9, Clause 2, the freedom of movement is more closely related to the rights of citizens to move freely throughout the Federation and to reside in any part of it, and that the aim function of this article was to remove all internal barriers within the Federation, rather than ensuring fundamental rights like liberty as protected in Article 5. When compared to the Movement Control Order authorized on 16th March 2020, we can see that the same principles apply. The COVID-19 pandemic is a grave public health hazard which at that time caused fatal deaths and had no immediate cure. To prevent the public from contracting the COVID-19 virus, the government placed restrictions on interstate and inter-district travel, aiming to prevent the spread of the virus and to delay the speed of virus transmission as fast as possible to give time to scientists to find cure and end the pandemic with low human life costs. So regulations were made under the Prevention and Control of Infectious Diseases Act 1988, which is a law on public health. Therefore, it is an exclusion to the rights to freedom of movement as stated in the Constitution.
On the 16th of March 2020, Malaysia's Prime Minister Tan Sri Muhyiddin Yassin made a national speech regarding the surge of COVID-19 cases in the country. In the speech, he announced that the government had decided to implement a nationwide restriction of an order from the 18th of March until the 31st of March. The purpose of implementing this order is to curb the transmission of this virus among the community and to prevent the healthcare system from being overwhelmed. The restriction of an order prohibits mass gatherings nationwide. This includes religious activities, social, sports, and cultural events. To enforce this restriction, all places of worship must be closed and religious activities, including the Muslim Friday prayers, must be halted. Business premises have to be closed except supermarkets, public markets, sundry shops, and convenience stores selling essential goods. This order also prohibits Malaysians from travelling abroad. As for Malaysians returning to the country, it is mandatory for them to undergo a medical examination and self-quarantine for a period of 14 days. As for foreign visitors and tourists, they are completely banned from entering the country. Other than that, it prohibits the operation of kindergartens, fully residential schools, international schools, Tahfiz centres, public and private schools, and all other institutions of learning in primary, secondary, and pre-university levels. All public and private higher education institutions, including skills training institutes, have to be closed as well. Lastly, it is compulsory for all non-essential government and private premises to be closed within those 14 days. This order is enforced under the Prevention and Control of Infectious Diseases Act 1988 PCIDA and the Police Act PA 1967. Although these two acts were used together to enforce the restriction of an order, the PCIDA was predominant to the constitutionality of the public health movement restrictions. The PCIDA is a legislation designed to provide support for the government to curb infectious diseases. As this legislation was passed in 1988, it did not foresee the coronavirus. Obviously, this virus is not listed in Part 2 of the first schedule. However, this disease can fall under the category of any other life-threatening microbial infection under the state schedule. Section 10, Part 4 of the Act imposes the duty on every adult occupant of any house who are aware of the existence of any infectious diseases in any premises to notify the case through notice with the least practicable delay to the nearest district health office or government health facility or police station or nearest village head. The same section also makes it compulsory for any medical practitioner who treats or becomes aware of the existence of any infectious disease in any premises to give notice of the case with the least practicable delay to the nearest medical officer of health. Section 11, subsection 1 of the Act states that if the Minister of Health is satisfied that there is an outbreak or threat of an epidemic of any infectious diseases in any area of Malaysia, the Minister may, by the order of the Gazette, declare such area to be an affected local area. Section 11, subsection 2 allows the Minister to prescribe measures to control or prevent the spread of any infectious disease within or from an infected local area, which in this case, it empowered the Minister of Health to enforce the restriction of movement order. Section 11, subsection 3 allowed any authorized officer to direct any person or class or category of persons to subject themselves to treatment or immunization, to isolation, observation or surveillance, or any other measures considered to be necessary. Section 12 of the Act imposes that it is an offence for anyone who knows or has reasons to believe that they are suffering from an infectious disease expose other persons to the risk of infection by their presence or conduct in any public place or any other place used in common by persons other than family members or household. Section 22, Part 5 of the Act imposes that it is an offence for anyone who disobeys any lawful order issued by any authorized officer or breach any rules under this Act. Any person guilty of an offence under this shall be liable to the penalties under Section 24 and Section 25. In respect of a first offence, the person shall face imprisonment for a term not exceeding 2 years, or to fine, or to both. In respect of a second subsequent offence, the person is convicted to imprisonment not exceeding 5 years, or to fine, or to both. In respect of a continuing offence, the person shall be convicted to a further fine not exceeding 200 ringgit for every day during which such offence continues. The director or any public officer authorised for this purpose may compound any offence under this Act, which has been prescribed by regulations as compoundable, by collecting from offender a sum of money not exceeding 1,000 ringgit.
Hi, my name is Siong Yu, and now I'm going to share an exceptional circumstances when Article 9 of Malaysian Federal Constitution can be overruled. There is a law that is relevant and in fact being used to deal with COVID-19 pandemic in Malaysia is the National Security Council Act 2016. This is an act which gives the government very wide powers to deal with national security. Under Section 3 of the Act, National Security Council is established as the central authority concerning national security. The National Security Council, in its national security policy, has identified outbreak of infectious disease as a disaster and therefore a threat to national security. Also, from Section 4 of the Act, the Council should have the following functions. Firstly, to formulate policies and strategic measures on national security, including sovereignty, territorial integrity, defense, socio-political stability, economic stability, strategic resources, national security, and other interests relating to national security. Second, to monitor the implementation of the policies and strategic measures on a national security. Thirdly, to advise on declaration of security areas. And lastly, to perform any other functions relating to national security for the proper implementation of this Act. While Part 5 of the Act stated special powers of the Director of Operations and Security Forces deployed to the security area. Section 22 to Section 36 are some important sections of the Act. Section 8 of National Security Council Act empowers the Yang di-Pertuan Agong to declare any areas in Malaysia as a national security area if such area is seriously disturbed or threatened by any person, matter, or things which causes or is likely to cause serious harm to people or serious harm to the territories, economy, nationality, infrastructure of Malaysia, or any other interest of Malaysia, and requires immediate national response. The declaration are valid for 6 months and may be renewed for 6 months at a time. Once a declaration is made, the Council may issue an executive order to the Director of Operators in relation to the security area in the interest of national security. The Director of Operations, together with security forces deployed to the national security area, are given very wide powers under the Part 5 of National Security Council Act. This includes the power to exclude any person from the area for a specific period, the power to control movement of any person or any vehicle, vessels, aircraft, or convenience in and out of the security areas, and the power to arrest. Given the wide powers conferred on National Security Council, it is fortunate that the government has thus so far only used the Council to coordinate the efforts to control the spread of the COVID-19 virus pursuant to the various orders and regulations promulgated under PCIDA, as well as pursuant to the Emergency Ordinance 2021. This is why the list of permissible activities and SOPs are to be found on the National Security Council's website, but the orders and regulations are all made under PCIDA and its regulations and or the Emergency Ordinance 2021. We are safely to conclude that National Security Council Act is an exception from Article 9 of Federal Constitution, and therefore restrictions of movement made under this Act is not a violation to freedom of movement. Thank you.
Fundamental liberties are the rights and freedoms that we have as human beings. And because the rights and freedoms are set out in the Constitution, they are said to be guaranteed and cannot be taken away from us unless the Constitution itself allows it. According to the Article 10 of the Fundamental Liberties, every citizen has the freedom of assembly, speech and association. And today I'm going to focus on the freedom of assembly. Every citizen has the right to assemble peacefully and without arms. According to the Law Dictionary, the assembly is defined as meeting together with a considerable number of persons at the same place. All citizens have the right to assemble peaceably with a freely choosing time allocation, for example, public streets, roads and squares. So, what is the importance for every citizen to have freedom of assembly? The violations to the right of freedom of assembly have a serious implications to the society as they deny an open and pluralistic dialogue. Additionally, the large-scale public events are a unique way for people to join together and acknowledge each other's support. The Brookings Institution, one of the United States' most renowned think tanks, found that this type of activities can be a catalyst for positive public change. For example, increasing the media coverage, influencing legislative action, and shifting the public opinion. The right can be justified in the case of Nasmin Ahmad and public prosecutor. In this case, the Court of Appeal unanimously affirmed the fundamental liberties to assemble peaceably. All the Malaysians are entitled to these freedoms and rights irrespective to their political and ideological belief. However, these freedoms and rights are not absolute because Article 10, subsection 2, 3 and 4 allows the Parliament to impose the restriction in the interest of the security of the Federation, friend relationship with other countries, public order and morality to protect the privilege of Federation. Under the Public Order Act 1958, the Minister temporarily declared any area where the public order is seriously threatened or seriously affected to be a restricted area in a certain period of time. This gives the police extensive power to maintain the public order for proclaimed areas. This includes the powers to close the roads, erect the barriers, to prohibit or regulate the assemblies, meetings, and processions of 5 persons or more. On 16 March 2020, the Acting Honourable Prime Minister Tan Sri Muhyiddin Yassin announced that the government has decided to implement the restriction of movement order in Malaysia to control the spread of coronavirus COVID-19. The order, which is made under the Prevention and Control of the Infectious Disease Act 1988 and the Police Act 1967, will be in effect throughout the Malaysia from 18 until 31st March 2020. The restriction of movement order includes the prohibition on mass movement and gatherings. Therefore, the citizens are not allowed to meet each other in this period with a freely selected time and place. In a nutshell, the Parliament may make laws to restrict these rights if they are necessary or expedient in the interest of the security of the country, public orders, and also morality, as what I've mentioned just now. As a result, in this situation, it can be said that the nationwide restriction movement does not violate or breach the fundamental liberties guaranteed in the Federal Constitution on freedom of assembly.
Now, I'll be talking about the freedom of religion as stated in Article 11 of the Federal Constitution. Article 3 of the Federal Constitution declares Islam as the religion of the Federation, but other religions may be practiced in peace and harmony anywhere in Malaysia. This article is in line with Article 11 of the Federal Constitution, which stated that every person has the right to worship or practice his own religion. This provision also sets out the rights to fund a religious institution, to manage religious affairs, and to acquire property. Aside from that, Article 12, subsection 3 and subsection 4 of the Federal Constitution further confirm that a person shall not be instructed to participate in any act of worship other than his own. However, his religion may be decided by his parents or guardians if he is under the age of 18. Although being a fundamental liberty, the right to freedom of religion is still being subjected to several restraints such as national order, public health, and morality. An example of case that would justify the right to freedom of religion would be the case of Teo Eng Wat and Kakhi Pasel Mas and another. In this case, a minor has been converted into a Muslim, and her father brought an action against the Supreme Court to declare the conversion null and void, as it was made without her father's consent. The Supreme Court then declined to make the declaration because the minor had reached the age of majority at that time. However, the Supreme Court do confirm that a person has the right to choose his own religion once reaching the age of majority. When freedom of movement isn't concerned, COVID-19 will be an example of public health that places restrictions on the freedom of movement. These restrictions include the prohibition of mass movements and religious gatherings as stated in Prevention and Control of Infectious Diseases Regulations 2020. This is so as the crowding of people will result in the spread of the disease, especially through religious traditions of kissing and hugging one another. Believers have argued that the restrictions placed on the freedom of movement had breached their freedom to religion as stated under Article 11 of the Federal Constitution. This is said so as the restriction orders indicate that religious institutions will be closed down and religious events are to be cancelled during the period. According to Tommy Thomas, the importance of organized religion and religious gatherings are ways of believers expressing their faith and religiosity. Therefore, the breach had no doubt posed a significant effect on the believers. As an example, a group of religious leaders had actually launched a judicial review in the Court of Session in Scotland, arguing that their freedom of worship had been breached due to the close down of the religious institutions. Therefore, this is no doubt a violation that believers find it hard to tolerate. Moreover, for the indigenous people that are mainly residing in Sabah and Sarawak, they find it difficult to cope with this violation. Most of them practice animism, which emphasizes the worship of rituals, spirits and natures, as well as performing rituals to express their beliefs. As an example, the Kadasan Dusuns viewed the Kaamatan as an important annual rituals to show thanks and show respect to their paddy goddess. Unfortunately, it was forced to cancel due to the restriction orders. However, some of the believers do argue that the breach should be a partial breach because the right to practice and worship had not been fully prohibited. Religious authorities of different states have been adopting measures to overcome the prohibition of mass movements and religious gatherings through online services and meetings. The dramatic expansions of internet have been fully utilized and relied on by religious authorities to go virtually or to form the digital religion. As an example, Christians are allowed to watch live services on various platforms such as Facebook and YouTube to join the mass. Furthermore, in the context of annual rituals, religious leaders had actually provided a digital platform that enabled people from around the world to join and celebrate the traditional rituals together online. Professor Sharp also stressed that the restrictions order only prevent people from going outside, but it does not prevent people from unleashing their spiritual force within their soul. Therefore, whether or not the freedom of movement had breached the freedom of religion, it depends on how this right has been exercised. People can still worship freely and show their faith or meet with religious mates virtually instead of physically. Article 11 of freedom of religion is still being exercised freely, just that the method to exercise it has changed.
My name is Siong Yu. I will talk about the Article 12 of Federal Constitution, rights in respect of education. Right to education is a fundamental liberty recognized globally in Article 26 of the Universal Declaration of Human Rights, which emphasizes the contribution of education in the full development of human personality. In Malaysia, Article 12 of the Federal Constitution set out clearly a person is entitled to education regardless of religion, race, descent, or place of birth. As for Malaysia, the main legislation governing the rights to education is the Education Act 1996. Some of the vital provisions is laid down by this act would be the compulsory of primary education, the consolidation of national education system and provisions regarding to different levels of schooling. These rights can be justified in the case of Jea Wen. This case concerned a minor who was disabled was being refused to transfer to the defendant's school, as the defendant argued that the school would be less productive and convenient for the minor, although being a disabled-friendly school. The court then allowed the minor's claim of interim injunction, reasoning that the physical handicap should not be reasonable to deny one's rights to education. Despite the case was discussed in light of disability and the need of spatial education, it nevertheless highlights the rights to education as a right not to be neglected. After the Movement Control Order, MCO, has started in Malaysia since 18 March 2020, all schools in Malaysia, including kindergarten, private and public education institutions, were forced to close down to prevent the spreading of COVID-19. A lot of students could not go to school for study and had to access online learning at home because of the nationwide restriction of movement. This had already breached the fundamental liberty of majority of students. Partially, the main problem that students faced was the internet accessibility problems. For instance, there are 52% of students in Sabah cannot access to internet due to insufficient of infrastructure. Besides, most of the students lack the experience of online learning before MCO. Hence, they do not have enough IT skills to solve the problems, such as how to join online learning platforms and how to submit their homework. On the other hand, some students also lack the motivation and interest in virtual class because they prefer study face-to-face. This is because students will worry about the problems of insufficient learning reference and could not fully understand the lessons. There are a lot of problems that may affect the effectiveness of students learning during MCO compared to study at school. Hence, the nationwide restriction of movement breach the fundamental liberties of students partially because students cannot have a good environment for study. Alongside this, a lot of parents face the problem to provide enough digital device such as smartphone, computer or tablets and internet access for e-learning study. This situation can be proved by the Minister of Education. He mentioned that 36.9% of all students do not have any devices on 15 April 2020. This already breached the law and fundamental liberties of students, especially the primary school students, because under Section 29A of Education Act 1995, it stated that primary education is compulsory education. Students who come from the low-income families do not have devices to access online learning due to lack of money. Some families cannot provide the devices for every child. This also caused some students cannot attend the virtual class if other siblings were using devices. Therefore, there are some students who are left out of education system. Generally, the nationwide restriction movement violated the fundamental liberty of students under Article 12 of Federal Constitution. However, the purpose of this restriction of movement is to prevent the spreading of a global infectious disease, which is COVID-19. Section 6 of Prevention and Control of Infectious Diseases Act 1998 states that the minister may, by regulation made under this act, prescribe in the measures to be taken to prevent the introduction of any infectious disease into Malaysia from any infected area. Hence, in this special situation, the nationwide restriction of movement do not violate the fundamental liberties of students.
The prolonged and heated debate as to whether the restrictions placed on freedom of movement is a violation of fundamental rights is still in doubt. The Parliament and other relevant authorities have always found it difficult to attempt to balance between protecting the interests of the public and the harmonization of the country. As in the case of a worldwide pandemic, There is no straightforward answer as to which rights are more important than others, but the right to life needs to be a priority, because without the right of life, the other rights cannot be established. Therefore, when public health is in concern, government policies, legislations, and objectives are justifiable in preserving general welfare and the well-being of the community, as long as it is made in the interest of the public, is respectful to human dignity, and is not discriminatory in nature. This is the end of our presentation. Thank you all for watching.